The order regarding appointment of personal representative. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine scale form PC 605. Scale for State Court Administrative Office, PC, Probate Court. This form is used in a very narrow, particular context. It's used following the appointment of a petition for removal or a petition to reopen an estate. So I don't want you to confuse this with the probate process involving a decedent in which you're asking for a petition for probate through a formal probate administration. There is an order, a scale form order for that particular purpose. So this is used in a narrow context. With all of these scale forms, they are created by various statutes and court rules, and there's quite a few of them here, as highlighted by the floating yellow arrow. The various MCL, Michigan Compiled Laws, and MCR, Michigan Court Rules, define the various aspects of this particular court form and give rise to how it was created and the language within it. So again, we strongly urge you to work with a skilled, competent probate lawyer to be able to guide you through a probate process, to know how to fill these forms out, to understand the language within the statutes and the court rules. This stuff is not intuitive. It's not simple to do or easy to follow. So understanding the nuances of the statute will be really helpful. Let's work our way through the form. First, as I mentioned, in the use note, in the highlighted red rectangle, it says this order is used with the petition for removal, which is a scale form PC 604, or with a petition to reopen an estate, PC 607. So again, in motion practice, you file a petition, you schedule it for hearing, it gets served with notice to the interested persons, there's a hearing, there's a ruling by the court in the form of an adjudication and order. And this would be the order following the petition for removal under PC 604 and the petition to reopen an estate under PC 607. Let's work our way through the document. Top left corner would be the case number and the file number. You'd identify at the top whether you're reopening an estate. The top part's pretty intuitive. The name of the estate, the date of the hearing, and the judge. Pretty basic, and then the findings of the court. And it's very typical within a court order. The top section are the findings of the court. The bottom section are the declarations or the order section from the judge and the court. Number 2 is a statement that notice of hearing was given to or waived by all interested persons. Then this is the case with all petitions that are filed. You file a petition, you must give notice. That notice can be waived by all the interested persons as defined in the statute as well as the court rule. 3, a petition was filed requesting a properly closed estate be reopened or an administratively. So proper is when you close it formally by a petition for complete estate settlement or informally with a sworn statement to close. Administratively is when the former personal representative failed to perform their role and the court administratively closes the probate estate. And in the next part of the section under 3, it says, and there is good cause to reopen the estate. So here this would be used if the estate is already closed and now it's being reopened because maybe you've identified a new asset or there's continued litigation going on that involves the estate. Now, the next section below 3 is, are you asking the court to reappoint the former personal representative, a successor, which would be a new one, or a special, which would be for a limited purpose. And that is the request that would be placed in there. Now, remember, when I say a request, these would be the findings of the court. So it's really mirroring usually the language in the petition, but after the court has ruled, is the former personal representative getting appointed, a successor, or a special? So this is the findings of the court here. Number 4, a petition for removal of the personal representative was filed by an interested person, and there was circumstances under 700.3611, which is the statute for that removal, has been proven or has not been proven. So this is the court's opportunity to make those findings. Number 5, at a petition of an interested party or by a motion of the court can do this, what we call on its own accord. The appointment of a special PR would need to be appointed. So again, a very limited circumstance where a special may be appointed to perform a particular provision or act within the estate. Number 6 provides Now, there's a lot of checkboxes here. The personal representative may have died, and there's a need for a successor to be appointed, which sadly happens quite often in state administrations. Had a conservator appointed for the personal representative, so the personal representative now is under their own incapacity in the form of a conservatorship, and a petition for appointment of a successor or special personal representative has been filed or needs to be filed. So again, this happens. The person who is in charge of the deceased estate then has their own disability or incapacity that prevents them from carrying out their role. The next section, there could be a resignation. So the personal representative says, I'm resigning. And then the next is that they should be removed because maybe they've done some malfeasance or breached their duty. Something has happened that there's a need for a successor to be appointed. Now, again, number 7 is simply there to remind the court, really, that there has to be findings made. The court can't just do this. There has to be findings, which means evidence has to be presented. The court has to make findings of fact, and conclusions of law are made on the record to support the rulings that the court is making here. And then number 8 is in the event of some kind of an emergency. So this would be an emergency hearing that would occur without the formality of normal due process in a normal petition waiting for a hearing. So there could be some emergency that needs to occur, and that's what checkbox 8 provides for. Now, everything below here, the order section, is really pretty much a repeat of what you just saw above, and now it's the court entering orders. So number 9 is identifying in the name of the personal representative that is going to be removed or permitted to resign, and whether there is a need for them to file a final account. That's the first checkbox. And then if there is property that is in their name or under their control, that it shall be disposed of as follows. So there's going to be some instruction with the court about what to do with the property. Number 10 identifies who now the new person is. Now, whether it's the former personal representative or a successor, this is the provision for the court to identify who the court is appointing to be the personal representative. Again, remember, this is after a petition for removal or a petition to reopen an estate, and whether the successor or a special or a personal representative. The next section identifies how they're going to qualify as personal representative. Do they file an acceptance of appointment, which is a form, a scale form, which I've explained in another video, or is there a bond, a surety bond, a guarantee of their performance? And what is the bond amount that the court is identifying? So if there is bond that's going to be issued for the person to qualify before the letters of authority can be issued for that personal representative, the personal representative would have to file the acceptance of appointment as well as qualify for a bond and file the bond of fiduciary with the court collectively before the letters of authority would get issued. The next section identifies the personal representative is not permitted to act until the letters are ordered. Now, here's why. You got a court order that says, here's how I'm appointing you, but you must first qualify. And then to qualify needs to occur before the letters of authority are issued. So you really have no power to act pursuant to this court order. You have to wait for the letters of authority to be issued to show confirmation that that personal representative has qualified on the appointment by filing the acceptance of appointment and the bond of fiduciary. The next section just identifies, is the estate reopened? Is there an expiration on the letters of authority? Is the special personal representative have a limited time upon which to serve? And there's a termination date. And 11 is really a simple one. If the court is presented with this court order and simply is denying the request for relief in that petition for removal or the petition to reopen the estate, court could just simply check box number 11 and says that the matter is denied, the petition is denied. A spot for the judge to sign and date, of course, this court order then kind of sets the motion for the next step, which is for the personal representative to qualify by filing the acceptance of appointment and or the bond of fiduciary. Again, not a simple process here, and we again urge you to work with a skilled, competent probate lawyer to make sure you know how to navigate through this very complicated process. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate, trust, guardianship, conservatorship related matter, Visit us at theprobatepro.com or call us at 1-833-PROBATE.